You may come across the phrase subject to contract, contract denied, from time to time. So if you're buying a house or buying a property, you might get a note from the auctioneer saying that it's subject to contract. It'll also arise if you are involved in any sort of a settlement agreement, for example, in an employment dispute. So you may have a dispute with your employer and it may go to the WRC, or it may not even go to the WRC. A settlement agreement may be proposed by the employer, and that settlement agreement will be marked without prejudice stroke subject to contract. And employees obviously are wondering, and other people wonder as well, what does it actually mean? Essentially, subject to contract means that all of the correspondence that's being entered into, any letters, any notes, any memoranda, any emails, all of these are subject to contract. In other words, until all of the terms and conditions of the final contract or agreement are arrived at, all of this correspondence is with a view to arriving at some sort of a deal. But essentially there's no deal and everything is marked subject to contract. In other words, until everything is agreed, nothing is agreed. And this way it allows people and individuals obviously to engage in correspondence with a view to either buying or selling a house, taking on a commercial lease, for example, on a property. It could be marked subject to lease, lease denied, and that is until all of the terms and conditions are agreed. For example, there could be a debate or negotiations obviously about rent, about the duration of the lease and so on. Likewise with the price of a house or any other special conditions, any other conditions that might arise or any other issues that might arise. Both solicitors will enter into subject to contract, contract denied correspondence with a view to eventually having a binding contract in place. As I say, likewise with a settlement agreement with the WRC or the Labour Court, or indeed a claim that an employee may bring to the civil courts. If there's a settlement, talks, and this would also apply obviously not just to an employment related situation, but to any litigation, any dispute. There's going to be an attempt to settle it normally. There will be correspondence entered into with a view to settling it, and that will be marked without prejudice, strictly without prejudice, or subject to contract, or both. So that's really the situation in relation to the phrase subject to contract. It has what's called suspensive effect. In other words, it suspends everything, kicks everything to touch, allows the parties to negotiate without being tied down or without fear of putting all of the cards on the table until there is an agreement in place or going to be in place, all of the terms and conditions having been agreed between the parties, and subject to contract on the correspondence, on a sales advice note from an auctioneer, in the correspondence between solicitors, or in correspondence between an employer and an employee, or indeed litigants in any legal proceedings, will be marked subject to contract, and that is obviously with a view to eventually arriving at an agreement. Thank you for supporting the channel and for your comments and shares and likes. And if you find this video useful or helpful in any way, I would appreciate if you give it a thumbs up. And as I say, if you're not already subscribed to my channel, you may be interested in subscribing to my YouTube channel.